Now recording. So welcome everyone to today's CLE, which is being presented by our platinum sponsor, Morrison Foerster. And we're going to learn about how in-house counsel can work with outside counsel and with internal teams to shepherd through the life of an invention. I really want to thank MoFo and all of the attendees here who are supporting our chapter. And with that, I'm going to turn it over to Eric Acker, litigator and partner at MoFo.
Hello, ACC world. Eric Ager here, litigation litigation partner at Morrison Foerster. You all know Rebecca, but I'm going to introduce her anyway. For you, those of you that don't know, she's an associate general counsel at Callaway Golf, where she's worked for nearly 13 years before going in-house. She worked both as a patent litigator and a patent prosecutor at law firms in Boston and San Diego. And I also have the pleasure of introducing two of my partners. Brian Cramer was also an IP patent litigator and IP litigator, often in life sciences and pharmaceutical and medical device cases. He has a degree in mechanical engineering and clerked in 2 courts for Judge Robinson in the District of Delaware, and also for Judge Lynn in the Federal Circuit. And he joined Morrison and Foerster almost as long ago as I did, 19 years ago. And then my other partner, Karen Parr, in our patent prosecution group, is a cellular and molecular biologist with a PhD from Duke and many years experience building, managing, drafting patents, managing patent portfolios in the life sciences space. She did her postdoc work at San Diego at the Holy Institute for Allergy and Immunology. And she too is, as I said, one of our partners here at Morrison in San Diego. So the title of our presentation is The GC's Role in the Life of an Invention. And we've lucked out because we have both outside counsel and Rebecca in-house to walk us through sort of the life cycle of identifying what needs to be protected as an invention, what path to take to protect it, how to go about it, and that's where we'll start. But then after we do that, we'll move into what forms of protection are probably the most suitable for different inventions. And then finally, we'll turn back to enforcing your IP, either offensively or defensively, and Brian and I will take the lead on that and following up with Rebecca and Karen. So, and if folks have questions along the way, we're going to save some time at the end, but we would like to make it as interactive as possible. So please chime in at the end when we get through the main part of the presentation. So steps to protecting inventions. Step A, identifying information to protect and freedom to operate. And we're going to let Rebecca take the lead on this one, followed up by Karen and Brian. So Rebecca, take it away.
Great, thank you, Eric. So just as a preface, what the things I'm going to talk about today are my opinions and my experiences working in-house for as long as I have. They don't represent the official positions or policies of Callaway. With that out of the way, I think my biggest goal when I started at Callaway and continuing my career there is making friends with the R&D team, making friends with the inventors, creating that personal relationship so that they know that I'm their partner. I'm there to support them. I'm there to help them. I'm not a roadblock to their invention or their design process. So this has a lot to relies on, it takes a lot of time, but it's critically important to make the introductions to the people who are actually doing the innovation, explaining, and this can be in the form of formal trainings or informal trainings, but explaining what patent counsel does, delineating between what clearance is, freedom to operate, and what patent prosecution is. There's a lot of confusion I found with inventors about the perspectives that are involved in each of those concepts. And also explaining to them how the process of clearance works and how the process of patent prosecution works. Once that basic foundation is out of the way, and they understand why I'm there, I sit in on brainstorming sessions. I help guide the conversation so that they can be aware of what might be out there in terms of patents and what opportunities might be there for them as well. But really developing trust between the legal department or outside counsel and the actual team doing the innovation is critical. I'm going to pause and let Karen and Brian jump in.
Yeah, so I agree with that. I think, so I'm Karen and obviously work at Morrison Foerster, as Eric noted, and I have only worked in the law firm environment and never in-house. And so one of the things that sort of as outside counsel working with various companies in protecting IP that is important is sort of to how do you open the communication between what the company has and what is patentable. Unlike Rebecca, I believe you do a lot of the prosecution and drafting of patents in-house yourself, and many companies do that, but a lot of companies don't, and a lot of emerging startup companies don't have their own inside in-house counsel and rely solely on outside counsel. And so a lot of times as outside counsel, we don't have the luxury of being able to attend many of these brainstorming meetings and being able to understand what the invention is. And that is, especially for startup companies, I think the biggest hurdle and struggle. I think startup companies who have a less sophisticated legal team necessarily also are the ones where their patent portfolio is probably the most important in terms of, trying to find investors, and really building up their company. And so it's the stage where you can mess it up if it's not done rightly. So as outside counsel, even with these smaller startups, exactly what Rebecca said is trying to open up communications, making sure the company knows, whoever you're working with in management knows how to identify inventions. And so having an invention disclosure system. And so Rebecca, it'd be interesting to know if your company has an invention disclosure system, because I think a lot of companies that do, it's often, and you train a lot of the employees on when to use and what to put into an invention disclosure. They don't necessarily have to decide if the invention is patentable, but at least it provides a mechanism for them to identify aspects that might be patentable and get it communicated to the appropriate people who then can vet it for them to determine if it's patentable. And I think that's what, even with sort of more mid-range larger companies, even companies with in-house counsel, I think having an invention disclosure system, and most companies that I work with do, I think really does help to identify the inventions and move it forward with the patent counsel.
So Rebecca, do you have a similar system, or are you the patent disclosure system at Callaway? And then maybe you could talk a little bit about how you formalize that, and then maybe talk a little bit about when it is that you will reach out to outside counsel and not deal with protecting the IP in-house by yourself.
So that's a really good point, Karen and Eric, that you're making. Having that invention disclosure statement is critical, because it also helps identify for the people filling it out what the critical pieces of information are, earliest date of conception, who the inventors are. Again, a lot of this requires training just to use it. People need to understand what an inventor means under the law, but it provides a template for them to build off of. So I do have an invention disclosure statement that I ask people to fill out. But again, once you've developed these relationships, sometimes I'll just get, back of the napkin type sketch, you'd like to do this, and you work from what you've been given. But those are tend to be the more experienced patenters, not so much the new ones. But yeah, it's also great for keeping track of inventions. And I know we're going to talk about this later, but that may not end up becoming patented, but you can treat that document as a trade secret that identifies the trade secret for you going forward.
And then what are your tricks, Karen, to get an emerging growth company that's laser focused on raising money, getting their product into the clinic? How do you get them to focus on inventor disclosure statements, getting you the information that you need to protect their IP.
So I think to Rebecca's point, making sure the company and the employees understand what the patent system is. So for really companies that are sort of startup, I have participated in trainings where I give sort of an overview system of the patent process and procedures of how employees and scientists at the company can communicate their inventions. And so just letting them know that such a process exists. And when there is not outside counsel and it's sort of the CEO and other upper management, having to work with these people, they often do ask us as outside counsel. Beyond that, when I do have calls, you just have to ask questions and you have to probe people. Okay, what are you developing? What is your timeline? And really start strategizing about when is it ripe to patent and follow up. So what I do is, I'll randomly have these calls with various clients and companies, just, about whatever, but don't just leave it there, make sure to follow up, because otherwise I think people, especially at this early stage, lose sight of the opportunities to file a patent. And so just being proactive about that from the get-go.
Yeah, I often find that inventors and executives become laser focused on understanding the patent system after they get involved in litigation and have to try and protect their patents. I don't know, Brian, if you want to chime in on this first topic.
I just want to say that I think that as a litigator, the things that I would like the inventors to know is to disclose everything, and that let the lawyers spin the facts. So they want the good and the bad, because if the case, if the patent ever gets enforced, they're not only going to ask for the invention disclosure agreement, but they're going to ask for the lab notebooks and everything leading up to that. So give your counsel the good facts and the bad facts, and let them be the spinners of the information. And then from the lawyer's perspective, in-house, I'd like the in-house folks to think of their inventors as future witnesses, so that not every single patent is going to be enforced someday, but there might be a point where you realize this could be a valuable tool within the company. And as those inventors go on to other companies, it's always a good idea to get them into a consulting agreement, or have some part of their severance agreement to include some cooperation going forward, because the named inventor is almost always a witness in a patent case. It's very rare that they're not. And if you've got them under your control, it's always better than worrying about what they might say 6 years after they leave the company.
And if you're trying a patent case, you need to tell a story. And it's, if you are a plaintiff in a patent case, it's very difficult to describe the aha moment, to describe the invention, unless you've got a really strong witness who is integral in the conception of the invention. And so thinking about that, even though, it may be years down the road, as Brian says, having those people have good relationships with those folks, make sure the lab notebooks are squared away, or other engineering documents for clubs or whatever are kept in an orderly fashion, so that you can recreate the invention moment in a courtroom is critically important. Anything else on this first topic from my panelists?
So you had asked me a question earlier about when to engage outside counsel.
Yeah.
So I think it's very important for in-house counsel to know their limits, know when they need help, not be afraid to ask for help from outside counsel. Especially if there's a lot of volume coming in, or a lot of quick deadlines you have to meet. Engaging competent outside prosecutors, it's a necessity. So for those companies who do have in-house prosecution teams, identify now who you'd want to work with for your outside counsel, because if you suddenly get an influx of hot designs that are going to be presented at a conference or at a trade show in a week, you need help. You need to do it right now.
And to add to that, I think that's a really important point. And one of the things I'll say is I think of the companies that I work with as partners, and I hope that they think of me that way too, that we're sort of all on the same team. We're here to help them, but that requires building trust. And so I think finding outside counsel that you trust and who would be ready at the moment's notice to file a patent applications for you. If you sort of treat outside counsel as like, well, they're so expensive, we never want to use them, and don't sort of appropriate the right relationship at the get-go, you might not have the resources available at the ready when you need them. And really, I think having that trusted relationship it benefits everyone all around.
Yeah, 100%.
And it's a bad strategy to be penny wise and pound foolish when you're prosecuting your most important patents, because if you ever do have to defend them or assert them, a little extra care and a little extra legal spend up front is going to go a long way, particularly when you balance that against the costs of having to defend or prosecute a patent prosecution action with a patent that's got some vulnerabilities.
And especially for startups or whose, the patent is your equity, like that is when you invest. You need to build that portfolio.
Okay, so you've identified an invention, you've made friends with your engineers or your scientists, you've secured their lab notebooks. How do you decide what you're going to do with all that information? We'll start with Karen and then go to Rebecca and Brian.
So I work primarily in the life sciences space, which is a very hot area right now. And I think it depends, to answer that question, it depends on who the client is and what the need is. I think sort of the most robust thing that could be done is that if you're given an invention, you first of all, you meet with the scientists themselves, you make sure you understand it in as much detail as possible. And then you decide, is a prior art search necessary? Is there, first of all, I guess it depends on the nature. Immediately right away, you might decide, what type of IP protection is this? As a life sciences attorney, in general, most people do file patents. I think there are some aspects that are kept as trade secret, particularly details of methods and processes and all of that is kept trade secret. And there is discussion of that, and there should be an open discussion about what to protect versus not. But in general, particularly in view of the ability to quickly reverse engineer and figure out what your competitors are doing, the patent process is what most clients I work with do choose. Once it's decided, then the decision is made whether to do a prior art search. I would say the majority of the time we do not do prior art searches before filing a patent application. And one of the reasons, I think the main reason, is cost. It just costs money, and maybe it's so early in the cycle of really knowing the value of this invention to the company, and sort of later, when you're at the next juncture of cost to figure out whether the invention really makes sense to move forward or not, companies would decide to potentially do a prior art search. So depending on whether you do a prior art search or not, then we just sort of start brainstorming about the strategy of what to protect and how to protect it, in terms of drafting claims for a patent application and engaging in back and forth. Rebecca, do you have a similar procedure?
Yeah, I have a similar perspective, and same ideas about prior art searching. If the invention is something that is likely to go into a product, then we'd probably be doing a clearance search anyway, and that would be a separate process. And so anything that came up in that clearance would obviously be disclosed in the application. But if it's blue sky research, we probably will save the time and the cost of a prior art search and just file the application. Also, it makes it, you can do it more quickly if you're not doing that prior art search. For people who are in like software, you may also want to consider filing a patent or keeping the process a trade secret, but definitely copyright protection is something to consider for the code. So just another thing to consider while you're doing the analysis.
And what about the trade-off between, and Karen, maybe this is, you can start with this. If you've got a company that wants to publicize what they've discovered, and yet, you have the yin and yang of maybe it should be a trade secret. Should they publish? When should they publish? And I assume at Callaway, there's instances where you want to broadcast that you've got the latest and greatest golf club, but maybe there's a tension between that and when you get your provisional application filed or your utility application filed, or maybe you want this to be trade secret because for some other reasons. Maybe you could talk a little bit about those considerations.
I think, and that's one point I was really wanting to make sure to emphasize here is companies do want to publish. At least I think the bigger companies in life sciences and pharma, a lot of companies are a little bit more restrained about what they publish, but young companies, startups, necessarily in order to attract investments, have a really necessity in some ways to publish. And it really is a balance. And I think it's probably one of the most important strategic aspects to consider. And really that when you're opening up the line of communication with the company and just understanding what they're doing and when they're publishing, I can't tell you how many times I've been surprised at finding stuff that the companies publish that they did not share with me, particularly on their websites. Happens a lot. Even clinical trial postings without sharing it, just randomly coming across it. And it seems, I think when a company just gets, they're on the trajectory of getting a product to market, I think they forget how important every little thing matters to the patent portfolio, and just making sure that the Patent Council and IP Council is aware of it. In terms of just, in my experience, I think a company decides to publish because they think they need to. Usually the business needs always outweigh the patent needs, in my experience, typically. There is negotiation where the patent team can, negotiate with the business team and say, well, maybe you don't say it that way and you use a different word in how you publish. Maybe you refrain from including these details. But there is a real important need to have the both sides of the company communicate, the business side communicate with the patent side, and then if there's an outside counsel, communicate with the outside counsel, just to figure out those nuances. But ultimately, I think a company is going to publish, and I think the patent team has to sort of be reactionary to that. And I think that especially is true for startup companies, for sure.
And Rebecca, do you often make that decision to not to patent, but to keep it as a trade secret? And how do you go about deciding what you want to do?
I mean, at the end of the day, we want to know, is this something that could be reverse engineered or viewed or figured out relatively easily by a competitor? Because if it's a process that only the supplier or our internal teams are going to know about, we don't necessarily want to go and teach everyone what we're doing. So if it's something physical, if it's a physical product, we err on the side, we're going to try to patent it. Because, again, our technology is what sets us apart, and our marketing teams are eager to say as much as they can about it. So we try to file early and often so that the marketing team doesn't feel constrained about what they're saying.
So we got a question from Jim. How do you choose between trade secret versus patent when an invention is a manufacturing process that really affects quality, for example?
That's a very good question. I think, again, it comes down to, could this be reverse engineered? Because keeping it a trade secrets are forever, as long as you do the right things. Patents are 20 years from earliest filing date. If we think it's eventually something that will come out, we'll probably try to patent it. Or if we think that, if it's something that is eventually going to be figured out, we would err on the side of patenting it.
Yeah, I would say in my experience, a lot of companies, I work a lot in the cell therapy space, where a I don't know how many of you are familiar with that in the life sciences area, but the methods of how you make and manufacture cell therapy are pretty critical to the ultimate product, and therefore having patents that cover the methods are important. It's a really hard balance because the question that we're often asked is, well, how are you going to enforce the patent? So it's not even always, can somebody reverse engineer? It's, can you even enforce it? How do you know somebody's infringing your method and doing the exact same thing you're doing? So I think of it sort of basic, clear steps that you do think you would be able to at least have some insight on. It's important to, I think, protect the method with a patent. If it's an optimization where it's a particular concentration of a reagent or a particular buffer or the timing of when you incubate something, I think those aspects are probably often, not always, often best kept as trade secrets, because those would be, I think, even more difficult to really know to enforce. And I'm sure Eric and Brian probably have some insight on that point.
Well, just from trying a patent case and trying a trade secret case are a totally different process in that, you know, you need to make a decision early on if you're going to keep something trade secret versus patented, because once it's out of the box, it's out of the box. And in a trade secret case, the defendant will spend the entire discovery period just trying to find stuff in the public domain or find areas in which you have failed to button up and keep secret what you claim to be your crown jewels. That's typically the guts of a trade secret case. And Jim followed up and said, we get employees that leave and we are afraid they'll likely take those processes and implement in their new company. Well, do you have agreements with those? If you're going to keep a trade secret, do you have agreements with those folks that they need to keep confidential, you know, what they've learned while working for you? And if not, then the patent is the way to go, because that's, they can't get around that. But again, you're going to have to wait to the patent issues. And as Rebecca says, there's trade secrets are forever, patents are not. But in my experience, it's pretty difficult to keep trade secrets other than maybe the formula for Coke for more than 20 years. So that's a tough sell. I don't know, Brian, if you have different thoughts about litigating trade secret and patent cases.
The thing that comes to mind, if you decide to go a patented route for the process, you don't always have insight whether your competitors are using that process. So that's the problem with, you know, after 18 months, that application is going to be published, and then you've disclosed it to them, and it might take you many years to figure out that they've copied that too. So it's just another, may not need to get quite to 20 years of value to make the trade secret the better option. If it, you know, just think about what's going to happen in 18 months with your competitors, and are you going to get in a peek into what they're doing? It's not always apparent.
I will say on the trade secret question, I'm not an expert by any means on trade secret law, but it's more than just keeping it a secret. There has to be a clear policy in place at the company for protecting the confidential information. And so if you don't have a policy, if you're not consistent in your policy, and you don't have true measures in place for keeping information confidential on a need-to-know basis. So for example, not everyone at the company should know all the aspects of any given process or procedure. And if the company has a place that sort of protects on a need-to-know basis those people that need to know as part of an overall policy, that is really important if you ever are going to think of actually, you know, relying on a trade secret in the future. And so I've specifically at smaller companies, I think people forget about trade secrets or just think, oh, all a trade secret is, it's just, we just keep it secret and don't tell anyone. And they don't actually have these policies in place. They might have, I mean, as Eric said, if you have like a clear, you know, your employment agreement and keeping everything confidential, then when people leave the company, I think that is a measure, but I'm not sure that that's enough if the company hasn't really done anything more to keep the information confidential. So that, I think that is something that does warrant, in my experience, sort of more seriousness at companies is how do you actually protect your trade secrets in a way that you then, if you want to enforce somebody who's gone and stolen them in a case in the future.
And I see from the chat, there's a point that employees leave and we'll take it. And Steve Michal responded that sending reminder letters is important, and I agree with him completely. Reminding both the departing employees that they've signed agreements and that we are going to be watching you, and also reminding where they're going, that the in-house people who they're going, I think is very effective.
And hygiene in those processes, maintaining hygiene in those processes and consistency is super important too, because in the give and take of employees coming and going and just running your business, inevitably, or very often, if you're not diligent about it, those agreements, for some people you do it, but you don't do it for other people. And that just creates a defendant's dream in a trade secret case to show that you were really sloppy with really trying to protect what you have. And as Karen mentioned, having written consistent policies that you actually follow is super important in protecting something that's trade secret.
Yeah, if you don't follow your policies, they're worse.
Yeah,
worse.
you're worse off.
Yeah,
you're worse off if you have a policy you don't follow than if you don't have a policy, frankly.
Exactly.
So to get back to Eric's point of being a storyteller, if you're going to enforce your trade secrets someday, a nice actual safe with a comma big dial on the front of it is good for storytelling. So have them put it in the vault, because like Karen alluded to, it's got to be just something above and beyond your regular security. You want to have some restricted access to, not everybody in the company can access it, etc. But nice safe is good for a nice picture for the jury to look at. Bring the safe in to the courtroom.
All right, Rebecca. So if you decided to go the IP, the patent route, how do you decide where to file beyond the US, PCT, other countries? How do you make those determinations?
So in my experience, you look at where you're most likely to need to enforce it, or the jurisdictions that you expect to have most of your business. If it's a manufacturing process or like everything's going to be made in one country, you'll definitely want to file patents in that country so that you don't have people knocking it off where it's being made. And then of course, looking at where your biggest sales, your markets are for biggest sales, you'd want to file there as well. So it's, my experience is predominantly US, but definitely I've done PCT applications for China and Japan and Europe.
I was just going to say, you must have a lot of Japanese patents in the Gulf world, I would think. So
yeah, Korea is also a good place.
And then Karen, what do you do on an emerging growth company that's sort of on a shoestring budget? How do you counsel them on how global they should go with their patent portfolio?
That is always tough because it is a very expensive process. There are ways to delay costs. So for example, we just alluded to the PCT. That is a system where a client can choose to file a PCT application, and it sort of is a holding ground for 30 months. And then you ultimately decide where you want to file more broadly throughout the world. Not all countries are members of the PCT, but most countries are. The exception is, for example, Taiwan. So if you have a market interest in filing in Taiwan, you would need to file directly in Taiwan and would not be able to rely on the PCT. But if you use the PCT as a filing procedure, which I would say predominantly in the life sciences space anyway, most clients do, you then can defer your decision and your costs in large degree for up to 30 months before you have to decide where to file throughout the world. So if you're lucky in that time, the company has some leeway to figure out, are they going to have a partner? How commercially relevant this is going to be? How valuable is this? When you're finally at the decision point, when you do have to make your decision, I would say generally, at least in the life sciences space, most clients, even emerging companies, file in sort of the big 5 countries, which is the US, Europe, Japan, China, and Canada. And that has been pretty consistent, and I think still is pretty consistent. I think beyond that, people, really it just depends on, potential for the product, how much money the company has, because other countries I mean, China and Japan have high translation costs. That is one of the big five, but other countries, Brazil, Mexico, a slew of other countries that people could file in, it can get very costly quickly because of translation costs. And that it just really depends. I think big pharma companies file in anywhere from, 15 to 30 or more different countries, depending on the product. But really, it's the big five that are probably where most of your value ultimately comes from.
Yeah, the way I would think about it from a litigation standpoint is where are you willing to enforce? Where do you want to enforce your patents? Flip side of what Rebecca said is, where are our markets? I don't know that you would necessarily want to spend money to get a patent in somewhere that you're not really interested in spending the resources necessary to enforce it, and maybe understanding what that means in that particular country, because it's different in everywhere outside the US on how you enforce it, how much that costs, what that forum looks like. And so spending some time understanding, what's our market there, and can we really do anything with a patent in that country, and balancing that against the resources necessary to get that protection.
And I think another thing is understanding who your competitors are, which I think is another topic we're going to discuss at some point, because understanding where your competitors are also might play into where you want to file. I guess if you really truly think it's not a market for you, even if maybe you have a competitor in that market, maybe you don't care, but you very well might, especially if it could be blocking against them. So understanding competitor landscape is important for making the decision for filing.
I'm sorry, go ahead, Brian.
I was going to say that's also related to maybe the way that you want to draft the claims is to kind of give yourself some leeway as to who you're going to sue. You can draft a claim so it's the customer who's doing the actual infringement, or the manufacturer, or somewhere further upstream. And it's always good to have options, because if the direct infringers in China, that might be harder to enforce if you have some claims drafted to a middleman somewhere who could be the person that you're actually suing. And thinking about, you wouldn't want to draft claims so the end customer is the infringer, because they may be your own customers. So something to consider. And then also, are you able to go after the deepest pocket, depending on how you frame it? If it's a $1 chip and you sue the chip maker versus the car that $1 chip goes into, and you want a royalty of the car sale, or you want a royalty from the chip sale, something to think about. May not be the most natural way to describe an invention, but you want to do it so that you can go after the right person.
Rebecca, have you overseen litigation outside of the US for Japan or other countries?
Yeah, I oversee global litigation, and I've done litigation in my past jobs out of the country. So, it's very different overseas than it is in the US. So understanding where you might be litigating and the culture in which you're litigating is very important when making those decisions.
Does that drive your decisions on where you get patents?
Not personally, not strongly, because especially if you're trying to build a patent portfolio, you may just want volume.
Yeah.
But in terms of taking the step to enforce it, yes.
I also think one last point about where to file is also what is patentable in the various jurisdictions. Can you even get a patent there? So at least in the life sciences space, for example, methods of treatment are not patentable in most jurisdictions, except for the US, Australia, and a few others. And so you can redraft your claims when you, for example, clinical type claims and treating diseases as sort of use claims related to the use of the product itself. But different jurisdictions, if what is patentable is actually, for example, a novel dosing regimen, or a subset of patients that you're treating that you've now recognized, for example, via some personalized medicine diagnostic, is the superior group of subjects to treat. In certain jurisdictions, those features are not given patentable weight, because you're having to rely on the features of the product itself, not on the method aspects. And so that, of course, having knowledge of that, so you're not wasting resources up front, getting all these translations, and then, oh wait, it's not even patentable.
Okay, let's switch gears to enforcement and enforcing the IP. Let's start with Brian. How do you decide where and what to do?
Well, I guess starting with what to do, you'll have clients come to us and they'll find an infringer out there. Somebody's infringing their patent, and then they want to know, should we sue this person? You got to ask yourself, well, is it worth it? If this, little tiny competitor of 3 employees is doing $10,000 worth of sales, is that going to be worth subjecting your patent to a potential validity challenge? That's something you need to go, you don't want to see infringers at all, but you need to make sure you're not jeopardizing your patents to the delight of your arch rival at the expense of the $10,000 infringer out there. But in terms of where the jurisdiction cases have kind of changed over our careers, people were flocking to East Texas to get a plaintiff friendly jury and stuff. And the Supreme Court has curtailed that a bit. And now people are going to West Texas, but you got to go somewhere where the defendant can't play games and get rid of a case. You often prefer to sue people in your backyard to have a hometown crowd, but you could spend a whole lot of money filing a case in San Diego only to get it sent up to Boston or wherever else. Could slow you down a little bit in your pursuit. So those are the things that I consider, and agencies are also an option in patent cases. Of course, if you're on the defensive side, you may want to put a patent into an IPR at the patent office instead of filing a lawsuit in district court. Depending on what your defenses are to that patent, if it's a real art-based defense or something that's going to be so technical that the patent office is the better audience than a jury, that's something to take into consideration. But if you have a good story to tell, or if you have a bad story to tell, those are things that might drive you to or away from the patent office instead of into a district court.
Yeah, just in terms of venue selection, it's really where is the defendant. The rules now are pretty much where is the defendant resident, and they have to have brick and mortar somewhere or where they're incorporated. So it's typically often Delaware and where they have brick and mortar. It's sort of the rules now. And you should really understand, because it will be critically important, what the potential jury pool is like there. What are the district judges like in that jurisdiction? Do you have experience, or does your outside counsel have experience in that jurisdiction? Because there's large varying degrees of sophistication amongst different district courts in terms of understanding patents, being willing to invalidate patents. Do they grant summary judgment? If you're a plaintiff, are you likely to get past summary judgment because they never grant summary judgment? East Texas and Delaware come to mind in that regard. So it's a very, you need to be very strategic about deciding where you pull the trigger. It's a big decision. And Rebecca, maybe what do you do with trolls or NPEs? Callaway must get tons of letters from inventors who claim that duffers who claim that they've invented your golf club. How do you prioritize those, and do you ever make a decision that you're going to file a deck relief action? And I assume it must be a more significant product if you were to do that. But how does that funnel work at Callaway? So
typically, if we get a troll related letter, we'll do our due diligence to see, does this entity actually follow through on its suit, or if it does sue, will it back off if we start aggressively engaging? And then in terms of defense, we always look for which counsel has fought this troll in the past, who has the most experience with them, and then we go and hire them. Or at least this is my experience. I can't comment on our whole history of this kind of defensive activity, but look for the most experienced counsel in this area. Or they will be able to give you good, solid, lower cost advice. I think it may be important to mention also, if you're trying to pursue an infringer, the ITC. I think you might, if you want to just mention that, that's another option for relief.
A great choice, because if you really just, if an injunction is your number one priority, then the ITC is a viable option for you. You can't get any damages in an ITC case, but oftentimes the injunction's much more valuable. But we say that the product has to be imported from outside the country to make that a viable forum for you. But certainly
Yeah.
A fast forum also. The ITC doesn't mess around. It is lightning fast. It's be prepared to spend a lot of money, but in a shorter period of time. And I don't know that it always costs more overall compared to district court litigation, but the spend will be in the first 12 months and go very quickly. Now, there are other things when you're considering the speed of the jurisdiction. Let's say you have a Hatch-Waxman case, for example, and will you get a decision within 30 months or not during the 30-month stay that a branded applicant would get? That would be a consideration you would take in terms of speed of a jurisdiction. We want a jurisdiction that never decides a case within 30 months to make sure you're going to maximize the stay that you're going to get from FDA approval.
Rebecca, what about the flip side? When you have people knocking off your products, how do you decide whether you're going to sue them or not?
I mean, I think what you said, what Brian said before about assessing the real value of a lawsuit is critical. Because just something that's denting sales. Is it distracting our customers from what we're selling? And also, are there other means for which we can use to put a stop to it? Or is there trademark infringement going on? Is there false advertising going on? Patent litigation is very expensive and it's very disruptive. So try to assess, whether there are other causes of action that you could use to slow down the infringer.
A question: How often do you sort of negotiate with the other party via, if you have a patent and offer a license in exchange, sort of as part of a way to avoid a court case? Is that anything that ever happens?
It depends on the circumstance. If it's an entity that has valuable IP they'd be willing to share, then perhaps, or royalty is a possibility. It's really circumstantial.
And maybe Brian, you can address a little bit about the metamune dance and what not to say or say in a letter and
Yeah, I mean, that's the law kind of evolves over time with that also. But if you send a cease and desist letter, generally the first one you send, you don't want to be so aggressive that they could file a DJ action. And so that's standard, in the old test used to be the reasonable apprehension of a lawsuit being filed. But usually you can send a letter and just say, we see that you're selling this product. You may be interested in these 3 patents here because they're in the same field, get back to us. Now that doesn't have the level of aggression that you might want depending on what your objective is. But if you threaten too explicitly, you can subject yourself to being sued yourself. And so if you're going to engage in litigation, you're going to want to be the one that picks the forum. And if you're too aggressive in your cease and desist letters, you can wind up losing that choice that you make. So that's something you take into consideration of how aggressive and also who the sender is. If you're trying to get out of something and as you promise to stop or whatever your message is, you may want to have that just sent from the inside the company itself, or you may want to hire Morrison and Foerster to do that. And that might, 2 different reactions you can get is, oh, wow, they've hired, big law firm XYZ. Wow, they mean business. And we really didn't want to pick a fight with these guys, but well, they're really serious now. But also, wow, they must have a lot of money. They hired Morrison and Foerster, and now we can really extract some money out of them. So those are all of the things you would think about before sending a letter and what you say and who sends it.
And the flip side of that, obviously, is also notice requirements for damages. If you're not practicing your patent and if you are practicing your patent and you're not virtually marketing your products, you can't start the damages clock unless the other side does have notice. And so that's the flip side of a cease and desist letter. And for willfulness purposes, it's always nice when you're trying a willfulness case that you can establish without any doubt that the other side is well aware of your patents. They've looked at your patents and they're continuing to infringe. And so you need to be very strategic about being able to choose the forum that you want to be in, but also starting the clock on damages and also setting up your willfulness case on the plaintiff side. What about in the last few minutes that we have, Brian, defensive considerations?
Well, they're kind of the same in the sense of, who's the writer of the response to a cease and desist letter that you might receive, or different demand letters. But defensively, I think you want to know what your competitors are doing. Also, that you want to not be surprised by a lawsuit. You don't want to find out that your competitor has a patent from them when they're telling you about it for the first time in a cease and desist letter. So it's worth the investment to either do it in-house or to hire a service or a firm to, let them know who your competitors are. Please give me monthly, weekly, quarterly updates on what IP is being filed by those competitors, or have different alerts set, because as you see their published applications, you can make decisions about how to protect yourself, how to change a product, get ready to attack the patent once it issues, or protest it somehow. It's not always an easy thing to do, but some people, even while it's pending, they'll file protests, what we call them at the patent office. And that's not the formal patent office word for them, but keeping an eye on what your competitors are doing is key.
And I think just to add to that, it's incredibly important because keep in mind, the patent system is a public disclosure system. So all patent applications become public, but not for 18 months after you file them. So there's this pretty long, substantial secret period. I know for life sciences companies, that 18-month period, generally, they're still developing their product. So a lot of what Brian was just talking about, I think, is done more in still the development stage, where you're sort of have the luxury of figuring out what's coming out, before you've actually really decided on a particular candidate. But I know, in the tech space, I'm sure it's quite different. There's a lot of, and probably, I don't know, Rebecca, and what you're familiar with, but there's probably a lot of chance of the secret prior art existing and being quite relevant.
Well, there's also the whole, you can request that your application not be published. I mean, it limits your ability to file overseas unless you agree to let it publish. But if you're in the US and you want to keep your idea secret for a little while longer, your competitors might not have any idea what you're working on. So
Until
something to
you have a
consider
patent.
until the patent issues. But generally, I think it's good practice to have someone keeping an eye on what the patent landscape for your products looks like, so you can anticipate a potential fight.
Right. And if you're going to sue somebody, you need to know what they're going to come back at you with, and understanding what IP your competitors have and where you might be vulnerable, obviously, is part of the whole equation.
Yeah. Size up your competitor's rock pile.
And resources and their litigation history. And are they the type that have the stomach for litigation, and are they willing to do that? And have they done it in the past? Those are all considerations to take into account.
Yeah.
Okay, we're at 5 minutes to the hour. Jim and Stephen have been kind enough to lob in some questions, but we've got a few minutes left. So if there are any other questions from other folks, if you want to send it in the chat, here we go.
I also just want to say there will be slides. I believe there's slides that we're going to post to the ACC page, so that there are materials to look at in support of everything we've talked about. I see that Corinna says, do we use resources like RPX or Lot Network? I like keeping tabs on RPX to see how, which is a patent, it's like an insurance. I mean, maybe you guys can describe it a little better, but I like their notices, their weekly notices and updates, because they sort of show how patent law is evolving when it comes to more active NPEs or patent trolls.
Karen or Brian, thoughts on RPX or Lot Network?
Well, anytime you can, have a good source of intelligence about not only your competitors, but what's happening is is good. You know, I like to read IP Law 360 every morning to kind of read what cases are coming out, what verdicts are happening, what are the developments in the law, what's the Supreme Court thinking about taking on. Those things can vary, and in the life sciences spaces, we get pendulum swings on how the laws change in certain aspects. Not only in life science, how inequitable conduct has changed over time, how obviousness has changed over time. It's always just good to keep abreast of the law.
And I'll give a Morrison plug here. We have a weekly Federal Circuit blog that our appellate group puts out that does a really good job of summarizing the key decisions from the prior week. Also give you good statistics on how long cases are taking to get through the Federal Circuit. And if anybody doesn't get that, would like to get that, just reach out to one of us and we'll hook you up.
And then to the question about whether we should, about joining organizations like RPX, I think that's very industry dependent, and whether the patents that they have sort of aggregated licenses to really irrelevant to what you're doing.
Okay, we've got a couple minutes left. Any more thoughts, questions? Okay, do we have a MCLE? We have a CLA code that we're supposed to give out. Do you know, Rebecca?
I don't think we did a code on this one, but Audrey, I believe Audrey can comment on that.
There's no code. I'll be sending out the certificates later today.
Okay, great. Thanks.
Thank you.
Okay, so we're just about at the, oh, here we go. One more. Steve writes, do you suggest holding training classes for the company to make sure people are aware of patent issues?
Yes. Yes. I like to, in fact, I'm doing this later today. I'm doing a basics training to one of the groups in my organization, just to refresh, here's what patents are, because there's constant, people come and go, and just keep the information fresh, keep people aware, and you'll find that you have a lot more success in getting patents issued.
Yeah.
And also the understanding of the trade secret policy of the company, your trainings on that.
Yeah.
I'm not speaking for all law firms, but I think that your outside counsel love to come in and have reasons to come and see the folks in your companies, and often for free will just come in and say, let me give you like the top 10 worst emails I've ever seen in a case before, and what you should be careful about when you send emails to the company. And that's always enlightening. And I think, frankly, it helps the in-house counsel to have an outsider come in and say, I've told you these things, but I really mean it. And here's some real life examples about how things go wrong.
Yeah.
Real life examples stick in executives' minds.
And we're happy, again, Morrison plug, we're happy. We do it all the time. We'll do CLE presentations on any myriad of different topics in the IP space. And if you're interested, just reach out and let us know what topics you're interested in. We do this all the time, so we'd be happy to do that. Okay, we're at 1. Thank you, everybody. It's good to see people, at least virtually or by chat. And any closing comments from the crew?
I just want to thank Eric, Brian, Karen. I want to thank you guys for donating your time and for supporting us. And thank you, everyone, for attending.
Thank you. Have a good afternoon, everyone.
Bye-bye.
Bye.
Bye.
Hi, everybody.